introducing Jacob, who is the primary person in making decisions about which cases of ours get, or which cases of yours get assigned an attorney through the personal restraint project, petition project. Jacob works incredibly hard at this. It is a Herculean task because everybody deserves a lawyer and everyone should have a lawyer, and he has to make a decision about which cases have the greatest viability. Really, the goal of today is to sort of talk about ways that you can streamline that process and make it more likely that your clients will get appointed counsel. So, Jacob, I'm going to turn it over to you.
Thanks, Travis. Well, I guess the only thing that I would add as an addendum to that is that if I ever have any questions about something, I always confer with Jeff Ellis. So I don't want people to think that my limited legal mind is making all the decisions, because he's the brains of the operation. So I guess the first thing I'll do is sort of explain what happens on this side of things, and then maybe discuss a little bit how the 5046 project would be able to better serve applicants and, in fact, your clients with some intersection even prior to. I know a lot of times appellate attorneys actually seek discretionary review, even though it's not something they're necessarily required to do. But if you know discretionary review is pending, you can always fill out an application, and or you can fill one out while you're even waiting for an opinion from the Court of Appeals. So on this side of things, when we do a 100% review of all applications, and unlike direct review, where we know that a notice of appeal is absolutely guaranteed to be sent to an attorney for assignment, and then reviewed for whatever issues may be able to be presented to the review courts. The difference here is, of course, 5046 assignment is not a post-conviction assignment. It's not a constitutional right. And so what we have is we have a review team, because we review 100% of applications, and those applications come in a myriad of ways. A lot of times we'll get a phone call from somebody and we'll decide that it's a bit of an emergency, so we'll do a triage and actually fill out an application with the person over the phone. And or family members submit applications. The 5046 application is on the OPD website. And also we receive applications directly from people who are in confinement in Washington State, as well as from attorneys ranging from teen child, working with juveniles and JRA, all the way up to several of the appellate attorneys that I see here. And part of that review process is we go and we pull all the records from the trial court, and to include information, typically the jury verdicts. I'm always incensed when I see stipulations after a trial to criminal history. I think that's the wrong time to surrender the fight, particularly when I notice that they're out-of-state or federal convictions, because I think that those are always supposed to be challenged and or make the state at least do their job. So as pulling part of the record, we review judgment of sentence, statement of defendant on plea of guilty, charging informations, amended informations. I look for things like, was there some sort of pre-trial or pre-sentence review done to assess the mental health status of the person that's been charged in this case. And because one of the components for 5046 is, does the person have some sort of a mental health problem that might, and or other cognitive struggle that might impair their ability to seek post-conviction relief, basically like through the law library at the institution, with just trying to get peer support. So like I said, I just really try to have a critical eye on the records that we pull and then review. Typically, if it's been on direct review already, we get a lot of time-barred applications. Go and we read the opinion. If it's not attached to the mandate, then we go look it up in Westlaw. I can't emphasize enough, because I know that Jeff will be hard on me if I don't, that when doing post-conviction relief work, when doing personal restraint petitions, we do not follow the appellate track. Literally, as Jeff would tell us, what you don't know what you don't know. And in a personal restraint petition, I think a lot of times we're only limited by our own creativity. And I think that it takes a strong mind and an acute mind, keen mind, to sit there and try to think outside of the normal box. One of the things that we desperately need from appellate attorneys as the case is progressing is if you're hearing something from your client and or you're discovering something that you think would be better suited for collateral challenge, please memorialize it, because you make it a lot easier for us to recommend assignment and then to also secure assignment when we have something adequate that comes in that says, hey, look, I've identified this. I chose not to raise ineffective assistance of counsel on direct review because of these things here, but I believe that there's a basis for us which is fantastic for us. But I get a little bit out of order of operations by talking about that. You'll have to bear with my ADHD mind. So as our review progresses, we do look at a number of considerations. The age of the person at the time that the charge was alleged, the charge was convicted, the length of sentence, education level, just disabilities, health-related issues. And we always emphasize to applicants, and I would love for you all to have this in place, we don't care what the Department of Corrections says about somebody's disability or other things that might be inhibiting them. We view those things through the lens of how somebody would be treated in society, not how somebody is treated in prison. And if somebody in society would be viewed in a thoughtful way because they have some sort of a either physical or mental limitation, then that is precisely how we choose to view them as we review their cases. There's a few other things outside of the scope of the charter from the Senate, from the legislature that we consider. I personally consider the difference between a 25-year-old person serving a 10 or 15-year sentence compared to a person who's 60 years old or a person who's 55 years old, because those years are very different in the way that the toll happens. And when I'm put into a position where I have to make a decision between one of those two scenarios, I go for the person who the years are going to weigh more heavily on him. And it's an unfortunate fact that we do not have the ability to do assignment on all of the cases that merit assignment or all the cases that are eligible for referral to an attorney for assignment. And I would also speak on behalf of the attorneys that take the assignments. Not every assignment that we make is one that has any cognizable issue for them, but they put in a lot of effort in reviewing those things. Now, fortunately, we have funding for our attorneys to hire investigators and to secure expert witness testimony. Sadly, we haven't seen very much of those resources being used. Hopefully, Jeff Ellis can find time to start doing some training so that people can start learning to play in the gladiator's ring instead of the strict rules of direct review. That's pretty much, I guess, procedurally, after the review team gets its information entered with recommendations, we've developed an asterisk system, essentially, that prioritizes. I don't know how much the details of that are necessarily relevant, but triple red asterisk is absolute highest priority assignment. Double red asterisk is this case merits assignment, and the single asterisk is, hey, this case can be assigned. And the way that we typically work through that is it just really depends on how many slots we have open. Now, if in a previous month we had a triple asterisk that couldn't be assigned because we didn't have any places, and then this month we have 5 slots but 4 triple asterisks, we very well may look at the previous month's triple asterisk and see if that's still going to be something we can bring in on time. And if it is, we may very well assign that case this month. It's really just a lot of it is just about kind of just using the force. And I know it sounds a little bit silly when I say that, but when you start talking about personal restraint petitions and collateral challenge, you really just need to tap into something. And I don't know what that is. I don't know if Jeff taught it to me or if I learned it out of desperation or a little bit of both. Now, so that's really what happens on this side. As most of you know, we've recently had sort of a change in administration for both the appellate project and the 5046 project here at OPD. Katrine Johnson is now the managing attorney for the 5046 project. We're going to actually have our first assignment meeting with her today. Lucy Burke, who I see is present here, is OPD paralegal assigned to this project. She's extremely knowledgeable, thoughtful, and absolutely committed. I could not imagine doing this work without her as my team member and my friend. as it relates to what happens on the side of things with appellate attorneys, what we would love to see as time moves on and as this program, as this project becomes more familiar to people, is applications coming in. And as I talked about a few minutes ago, one of the most persuasive and influential things that can happen, and I see this periodically coming from some attorneys. I won't mention Nancy Collins because we know that she's near and dear to Travis, so we'd be prejudiced in this space. But Nancy Collins is a rock star, and I don't know who Travis Stearns is. Private joke. So if the attorneys can actually, when you're going through direct review and hopefully having communication with your client, I personally know, I know that Monica's here, so I'm sure he heard all of the lamenting Jody did about me and my impassioned pouring into her ear, basically vomiting into her ear over the phone, all of the things that I thought went on in my case. And I'm going to give you a perfect example. So right before entering my plea of guilty, I stopped the trial court twice to speak to my attorney. It's in the record that the trial court I asked the trial court if I could speak to counsel, but what wasn't in the record was what was that conversation about? And so that is where a person like myself, as a then incarcerated person, talking to my attorney Jody, I was like, hey, listen, I asked him to bring up the washout. I asked him twice to bring up the washout. And I told him when the judge said that this wasn't a prior conviction, he struck it from my judgment and sentence. He needed to bring up the washout. And he refused both times, but that's not in the record. But when your client tells you something like that, and you look at the record, you see, wow, wait a second, the court was stopped twice. And the second time the court said, hey, are you sure you're ready to proceed? And your client's telling you, yeah, well, listen, at that point, I just thought that my attorney knew what he was doing. So I took 30 years when I only faced 75 months. Those are the kind of things that you can memorialize because you have found something in the record that you can't really do anything with. But your client has said, hey, this is what happened in those spaces. And when you look at the scheme of things, you know that this is in almost certainty true. Those are the kind of things you can memorialize for us and then send that information in with an application that you fill out for your client, because that's an easy assignment for us. We look at that and we're like, hey, listen, this is going to be a great IAC argument, in a personal restraint petition, right? And those things can, they can vary in a number of different ways. But I think that most of you are all very talented and experienced, so you can actually see kind of what the theme and the thread is that I'm trying to encourage people to embrace. We really cannot have this program in a way that's robust and meaningful without your assistance, without your intersection. And that intersection comes literally at the time that you receive a case assigned and the beginning to view it through the lens of not just, hey, what am I able to present in a cognizable way here under direct review? What's clearly in the record, but also, okay, wait a second, let me make this footnote. And let me keep a little bit of a log going on that stuff, because that's invaluable to us. Like, I cannot tell you how useful it is for us when we're sitting here, we're trying to figure out, gosh, what do we do? Under the current fiscal climate, it's unlikely that 5046 is going to receive additional funding, but we anticipate sustainable funding to continue doing what we're doing. I can personally tell you that right now I'm in college because I want to become an attorney. Travis is going to make that happen. I don't know how. And I want to take over the post-conviction program here at Office of Public Defense. My goal is to see the post-conviction program grow into actually handling 7.8 motions, and to see it actually maybe potentially develop into a model like they have in Oregon, where there's a real meaningful review of pretty much all cases, which I know Jeff could probably speak to much better than I can. But as we said here, we view these things with our eyes on the horizon. The current landscape is skimpy and it's limited, but it's still here. And I'm going to always give fair weight and credit and due consideration to anything that I know a trained professional, like all of you appellate attorneys are, brings to our attention as, hey, listen, this is some stuff that should be looked at. So I don't know that I have anything else. I would invite Jeff to, oh, thank you, Catherine. I would invite Jeff to maybe tack on to this, because I know that he certainly has a longevity, which I'm not calling you old, Jeff, but you are. He has a longevity of experience and a lens to be able to see through these things that my I guess now 11 years or whatever of being involved in this does not offer. So, Jeff, do you want to make any contribution here?
No, not at this time. I'm sure if we get into some discussion, I won't be shy about speaking up. I almost never am. But at this point, you did a great job of covering that.
I think I saw Sean was here. Sean, are any of the 5046 attorneys present? If any of you would like to weigh in on this, because you guys are the ones who received the assignments, I would love for you to offer any input on what you would, like to maybe see coming from appellate attorneys.
Yeah, the only thing that I would mention is that hopefully more attorneys are aware of this program, because there's a lot of people that can be referred that aren't referred. I've got people call me from DOC about different things, and I let them know about the program if they're not able to afford to hire me. And so if there are different trial attorneys, different appellate attorneys that are more aware of this program, might get some more righteous referrals.
Yeah, and that, listen, that's one of the real problems that we run into is, like, I see case after case, which, in fact, I just reviewed one out of county, and I feel like was a big case a couple of years ago, right, Jeff? But this guy, he never even filed a personal restraint petition, and essentially he has a death in prison sentence. And I feel like, this is certainly the type of case where we should have at least taken a look to see if there was some way to try to, just keep him from dying inside. Oh, shoot. I just got big on the screen here, folks. And yeah, so, that's pretty much what I got. Certainly open for any questions that you guys might have.
So,
hey, can you tell us what the stats are like? Like, how many referrals are you getting? How many cases are you able to assign, and what kinds of issues are coming up?
Yeah, I can actually tell you what our assignments so far have been. Looks it's a little bit thin. Oh, there we go. Hey, Lucy, can you help with that? Can you give us a count on, because what I'm looking at here suggests that we've only had about 40 assignments so far, and I felt like it was higher than that.
We're at 55 so far. Roughly, I'd say it's about 10%. We're getting 30 to 50 applications per month.
Yeah, and we see a huge uptick on those applications when we manage to get into one of the facilities to, to have an OPD sort of informational seminar. We tend to go in, 5046 likes to go in with the Blake team because they're awesome. And we're only mediocre at best. No, I'm kidding. Lucy makes the 5046 team a rock star team, but we get a lot of literally 30 or 40 applications at that point, which can be a bit of a challenge for performing the rules or all the reviews in a calendar month. So we've been operational since, gosh, was it January 1st of last year, Lucy? Did we start accepting applications in December or January?
We started taking applications in December, but we didn't start the program officially until the 1st.
Right. So basically at 55 assignments in 12 months, you see, how those numbers break out for assignment. And I think one of the things that I've heard a lot of the contract attorneys who are handling the 5046 assignments talk about is the time that goes into it can be very different than that of direct review. I'll use Sean Devlin. He's God, man, he's a rock star, actually. That's not really the only way to describe the guy. But, when he gets into a case, like we did an assignment for him on a gentleman who was very aged and infirm and had recently had a resentencing. We had some concerns that appropriate mitigation hadn't been presented. So he gets into it. He discovers that, hey, they're actually going to let this guy go on emergency medical placement. And they had him assigned to like a transitional house or an adult assisted living place for him to go to. And he can't even get out of his wheelchair. And he's also a personal friend of mine. I used to actually push him around in his wheelchair. So when Sean gets into this, all of a sudden, the then Secretary of DOC denies the emergency medical placement for absolutely no reason given. Now, what that leaves him with is we have a number of hurdles, and I'll speak to one of these hurdles right now. It's an unfortunate fact that we don't have any right to discovery in the personal restraint vehicle when we're pursuing this. So we have to do public records requests, which is even just a greater reason to, one, create that right as a court rule, which, you know, maybe we'll get to a point where we're having talks with some of the justices in the Supreme Court about doing that. And or doing away with the time bar, which we've had a lot of discussion around because it's very impractical for a pro se litigant. It's very difficult for an attorney sometimes to secure the records and get it across the finish line in that 1 year. So Sean has to do public records requests to get information. Although that's not entirely true. If any of you need information from DOC, let me know and I can find all kinds of good stuff out. And what he ends up doing is now Sean is actually in his personal restraint vehicle. He's actually on a two-front battle. He's dealing with DOC and the Attorney General's office responding and the County of Commitment County. So he's fighting a multi-tiered, multi-directional battle, which, as you can imagine, can be a lot more time-consuming and just mentally exhausting. And he actually ended up with 3 of those cases. So the post-conviction program pulses quite a bit differently. I know that one of the things that I really want to explore with Jeff and Travis and Larry is how we can start helping resource the attorneys with investigators and with experts, because like those are really the ways that we're going to bring things. It's the only way to really get the courts to listen to any of this stuff. Like we know that this is a tidal wave of improbability that we fight against when we bring a PRP, and the chances of us getting better than a 1 in 20, if we're lucky, remand for something other than LFO correction. I just had to say that for Travis because I didn't want him to start gritting his teeth, because that seems to be the only thing the courts want to remand for today. In order for us to get better than that number, we're going to really have to start applying the creativity of investigators and experts.
The only other thing I wanted to know is if you see any trends of categories of cases that you're getting a lot coming through of one type or another.
Man, I'm so glad. Thank you for asking that, Monica. I do see a number of trends that alarm so yeah, listen, I got to tell you, I cannot emphasize, and it doesn't matter for us because I know that everybody in this space sees the same things. I really wish that we could find some way to get trial counsel to stop surrendering the fight at the end of trial. There should not be stipulations to criminal history unless the state's going to make a concession and recommend the low end or even a mid-range sentence, right? And we see that all the time. But outside of that, I see a lot of cases where a person is going to die in prison and they have not sought a personal restraint petition, never filed one. And I got to tell you, I see many cases where I think 13 PRPs was the most that I found from somebody. At those points, I mean, it's really difficult for us to try to get in because the chances of the court listening to something that even a counseled PRP is going to advance is very slim. So, I do see a lot of cases, murder cases, like life sentence cases, death in prison sentences, where no PRP has been filed. And I got to tell you, like, if there's any place, and for them, there was nothing for them to do, right? Because they were horribly under-resourced. If they had the money for investigators and for experts, they probably would have had the money to hire some attorney to try to represent them. And so absent the ability to do those 2 things, they certainly didn't have an attorney, or absent having the attorney, they didn't do those other 2 things. So they're just sitting there in prison because they have no resources. Well, today we have some resources, and it's not by no means is it like a bottomless well of financial resources, but it exists. So if you guys are coming across something and say, in fact, what I'll tell you, and I was talking to Travis earlier about it, and I'm going to take it to Jeff. I came across this case last night, which was very compelling to me when I was doing case reviews. It was a 2004 ROC first-degree conviction, and in 2022, the person was found to have stopped, to not have developed past the date of his 18th birthday. I assume the male pronoun there because I don't have any information otherwise. Now the real question there is like, hey, is there an argument? And since we have funds for experts, is there an argument that in fact he didn't develop to the 18th birthday, which would then make him developmentally a juvenile? And as such, is he entitled to a resentencing? Is he entitled maybe even for a remand for all new proceedings to make a determination whether or not it's even appropriate for him to be in, adult court, right? Maybe he should be prosecuted under juvenile court structure, right? So, I mean, that's a very interesting scenario for us. And it's one that, I know that we look forward to applying resources towards. And I'm also publicly putting this out here because I'm going to ask Jeff to take the case. And now I want to kind of twist his arm a little bit because he's going to have a hard time saying no in front of everybody. Those are the kind of things that we try to keep an eye out for. And then we have the resources, which, historically, like I said, the person inside who's facing life in prison, he doesn't even have the ability to get transcripts or, records. And we see a lot of people serving sentences that should have been challenged just on the basis of their length.
Yeah, I can add to that in terms of trends. I think one trend is you see a lot of understandably desperate people who've served far too long in prison, who are looking for any way to get released. And, in that, under that unfortunately far too big umbrella, there are cases, Jacob alluded to some of them, where they've tried to access the extraordinary medical release program of DOC, and DOC is indifferent at best to their requests. But, there's also some potential sentencing issue that could be raised. Which, is like a twofer, right? You're appointed on the PRP, but of course you want to attend to the other issue as well. There are also cases, there are a number of cases that I've seen, and I specifically have asked for cases regarding resentencing because that's sort of the place that I've been working. But there's a lot of cases from the recent set of resentencing issues, whether it's juvenile Blake or others, where people have been left out altogether. They didn't have the legal acumen to figure out how to get into court and press their issues, or even, frankly, whether they were entitled to relief. And then an appointment gets made. And in some of those cases, at least in some that I've had, those are cases where I actually start by filing a notice of appeal because no notice of appeal was ever filed before, and move to extend. So all with the idea that, for instance, if you followed the prejudice standard for sending a juvenile back for resentencing, it started out pretty good, and then it increasingly got worse and worse over time. And there's just no way, if you have the possibility of an appeal and the direct appeal standard, that you'd want to jump right into a PRP. But I think, overall, I would harken back to what Jacob said earlier, which is it's not so much geared towards what is this PRP going to look like when it's fully formed, because you don't know that until it's fully formed. But is there something wrong here? Is there an injustice at hand? And, if so, finally, here's a group of individuals, albeit a too small group of individuals, no fault of Jacob's or anybody at OPD's, that really deserve the guiding hand of counsel. So I feel like it's an opportunity for those folks who have been passed by and previously, with the eternal hope that maybe something will catch.
Hey, Jeff, would you you told me the story about was it the groundwater?
Sure. What
And just
aspect
to kind of give an idea of literally of how abstract it can be if you get in there, if you have an investigator get in there and sniff around.
Yeah, well, this is an old case that I did coming out of Washington State, but where my client grew up in Springfield, Oregon, and we were looking for reasons to mitigate his crime, which was murder. And we decided to go down to the Oregon Department of Environmental Quality and noticed that there was an airport basically about 100 meters from where my guy was living when he grew up. And because one of those big box retail stores had purchased the land that the airport had been on, they had to do some soil tests. And when they did these soil tests, albeit decades later, there were like 4,000 times the acceptable limit of long since banned substances like DDT, endosulfan, other things that cause brain damage, specifically brain damage to the frontal lobes, which are the control centers of the brain. And while this was horrifying, you know, it was the thing that nobody knew and nobody had looked at before and actually really related to the crime. And, you know, it's not that we went there because we knew that our guy's brain had been polluted. We went there because we didn't know what had happened. And it really became a key to the case. So that's I think one of those illustrations of, you know, if it had, you know, if we just sort of said, what do we know about this case when it came in as a request for a PRP, nobody would have known that that information was out there. That's, you know, that's the great opportunity of PRPs, is the ability to go out and investigate and find out what isn't known.
I mean, unless anybody has another question for me, I could try singing, make you all leave, or I can let Travis.
Yeah, well, Jacob, I have a question. It sounds to me like you're asking us to think broadly about the applications that we make and to be thinking more. For example, the case that you talked about with the older man, here's my case, and I saw him mostly just being too old to be in prison as the primary reason why we needed to file a PRP on him. And so I'm wondering if you could think a little, or encourage us, or think about where, so we know sometimes it's going to be obvious, right? So we see something that's ineffective assistance, or the possibility of ineffective assistance, that we really can't talk about on the direct appeal because there's just not enough of a record. So that's an easy one. But are there other circumstances, for example, sentencing, where the sentencing might have been okay, but that really, if we did more investigation, we would discover that he lived next to a pit of slime, and so that sentence is so egregious that it's worth applying for it, even though on its face it appears to be a valid sentencing procedure.
Yeah, first of all, I'm humbled that you would ask me that. Well, I mean, you know, like, so mitigation, right? Because that was our concern about his resentencing, was like, hey, listen, was any real mitigation presented? And at this point in the scheme of things, mitigation was the fact that, like, listen, he can't even stand up longer than 30 seconds. He had almost died sitting on the toilet in the prison. So, you know, could those things have been presented? And if they weren't presented, can we, because we can't just file a PRP and say, hey, they didn't present mitigation. We need to actually present the mitigation ourselves in order to, you know, to meet the standard of, you know, actual substantial prejudice. But we have the resources to do that. And that would include experts, and would also, you know, require getting DOC medical records and things like that. Because unfortunately, that's going to be one of your problems, anybody's problem with trying to make any basis, claim basis on a current medical situation, is the fact the Department of Corrections is the gatekeeper of all healthcare. They're inadequate. They're almost monstrous with it. And I have very personal feelings around that, because I have lifelong nerve damage in my arm and partial loss of use of my arm because of them. But we're only going to have the records that they have because your client doesn't have the ability to go out and actually see a normal medical professional who's going to do a real assessment of them. I've yet to see whether, or even explore whether or not we could use our resources under maybe the expert basis in order to actually get somebody to be taken out to be seen. I know it's possible. Certainly we can have, like, mental health, you know, psychological assessments happen. They'll go into the prison for that. But Yeah, mitigation. And, like, look, one of the things I see being slept on a lot here. Okay, like, case, let's just play make believe for a minute. Let's say he didn't have any trauma before he went to prison. You can bet that in the 20 plus years or 30 years, whatever, I think it's 20 plus years that he'd been in prison, you can bet that he now has a trauma history. So could there have been any meaningful presentation at his resentencing that, in fact, he suffers from, now from PTSD and from trauma, and that further exposure to the carceral space is going to escalate his death. Now, maybe the trial court wouldn't have cared, and in probability they wouldn't have. And nonetheless, it's also memorializing the record, which would then be something that could be sought on. And maybe, like in Light Roth, we get lucky with a panel of judges who just finally decide to say that they're going to agree with something. Happened in Blake.
Yeah, Travis, I would add to Jacob's answer that, first of all, if a case went through trial and resentencing, certainly, as Jacob says, it would be very helpful if you have some issue that you've seen, at least that's, ripe for a claim. Hey, this seems like ineffective assistance to me, or hey, this seems like some sort of evidentiary error, but it wasn't preserved, so I couldn't have raised it. Back when I was in the game of taking non-time barred PRPs coming out of a direct appeal after a trial, I mean, I felt fairly safe that I could say there wasn't a single case that would come to me where I couldn't find some issue. May not win, right? I mean, and it may not even be the strongest in the world, but there was always something out there that could be put together and become a viable issue. But the other half of that is just the sort of sense of, even if you don't see anything, there's just something wrong with this person remaining in prison, and we shouldn't just give up because we've reached finality, the end of the direct appeal line. Obviously better if you can identify a particular issue, but if you can't, you can't. I mean, I think, for instance, there's a lot of, and this goes back a little bit to Jacob's sort of statement of why are trial attorneys so willing to sign off on stipulations to criminal history? Not only that it exists, but that it's correct and it's scored correctly. I mean, the Erlanger decision from last summer by the U.S. Supreme Court opens up a lot of issues, right? And I suspect that you guys are catching them all now, but there's sort of a group of cases that didn't go through direct appeal where there are those sorts of scoring errors coming up. And I think also, again, this is sort of my bias, but I spent a lot of time trying to push the boundaries of what the sentencing rules are, right? What is constitutionally allowed. And that's getting harder and harder because of the time bar and because the court is viewing material changes as being only cases that, apply, are on all fours with your case, as opposed to being really close and trying to extend it. But any of those cases where, you feel like A, the sentence is too long, B, the sentence is too long for this person, or anything that resembles that, that's what we're trying to do, is to correct things that are otherwise, are left up to individuals to try to cobble together some pro se argument, which, even if it's good, chances are the Court of Appeals isn't going to pay very close attention to it without counsel.
Can I also say that overwhelming this program is important because we want counsel appointed in all of these cases. And if we can demonstrate to the legislature the great need for counsel, then we're more likely to get more funding. So I really just, on a purely procedural level or administrative level, overwhelm this program, really force Jacob and Jeff to really go through, and Lucy to go through so many cases that we go back to the legislature and say it's overwhelming and we need more money, because I think that's really important.
I don't want to hijack this meeting, but let me make a really fine point on Erlanger. I would like it to be able to look, it's not going to be applied retroactive because Blakely wasn't applied retroactively because it's the right to a jury trial, and that's a procedural issue, and it has not been held to be, bedrock procedure, and it's not substantive. But that doesn't mean it doesn't have application to old cases. Erlanger very clearly says this is about as obvious an application of Apprende as we can even imagine. So that means we can argue that it applies as of 2000. If it makes any difference in your briefing on direct appeal, I would not call it a new rule. I would call it an application of an old rule, because there's a whole bunch of people in post-conviction who'd like to trace it back to 2000 and Apprende. And of course, I think once the courts recognize its potential widespread application, there's at least going to be people in the courts who are going to push back on that. And so I'd hate to have us at odds with each other on that. Obviously, everybody's got to represent their clients to the best of their ability, but from my post-conviction viewpoint, it is a change in the law, but it is because it overrules some past case law, but it's not a new constitutional rule. It's a rule that springs from the fountainhead that is Apprende.
Comments? Anyone else? Questions for Jacob or Jeff or?
I did post my information in the chat if anybody comes up with something after this that they, or in the future.
Let me just say that this community is so well served by Jacob, who, as you've seen in his presentation, is smart as a tack and has a heart of gold, and that's kind of the mystery of getting these appointments. And we couldn't have found a better person in the world to do this than Jacob. So I'm a fan, and it's a tough thing because as he'll be the first person to point out, we just don't have enough resources to go around. But I commend his wisdom in making these sometimes awfully, Sophie's choice kind of decisions.
Yeah, I'll also, I guess I'll observe that I've never once assigned on a single friend of mine who's serving a life sentence, and I know they send those applications in with desperate hope, a Hail Mary pass, because they know Jacob's here somewhere. And it's a damn shame to me that there's no chance to help them, and that if there was some crazy if this, then this, if this, then this scenario, there's no way for me to objectively use our resources for that. So the work doesn't weigh lightly on me, but it's important. Anybody got any more questions for me? All right.
Well, Jacob, it sounds like be thorough in your application, think creatively about the issues, and write them down so that and when you feel that there's an injustice, the sentence is too long, your person is just something just feels wrong. Those are the kind of cases that you should be highlighting those kind of issues in, and you should be erring on the side of applying and not applying.
Absolutely. Listen, I'm gonna, if you send me an application with a message that says, hey, Jacob, this 20-year-old black guy shouldn't have gotten a life in prison sentence when the first time he's ever been arrested, I'm going to say, hey, you're fucking right. And I'm going to jump all over that, because for me, this program exists for the people, for specifically as a primary focus, people of color. And I have previously made assignments recommended assignments that were made because I had the choice between those very two factors and very similar sentence structures. Because for me, I'm going to err on the side of being too thoughtful around the way the system is developed. So like literally give me a reason, like give me a reason that's going to pull at my heartstrings. And I may throw all reason out the window if we can, because we want to assign on everything. You know, we can't necessarily assign on everything. And I think I see Mr. Weaver's here now. Like, look, you know, a lot of these cases that we send to the attorneys are ones that they're going to review, and they're going to say, hey, there's nothing. But I'm going to, again, I mentioned Lightroth a little while ago. We know Blake. Sometimes you just keep throwing till it sticks. And Lightroth, you know, materially, Lightroth was a dog. There were so many better cases, but it came down to which judge. Finally, the Supreme Court decided that Blake was, you know, that shifting the burden of proof to the defendant was a violation of due process. They've had that opportunity for 40 years. So sometimes you just keep arguing the exact same thing, keep trying. And that's how we hopefully eventually make progress. Is that not your sense of this too, Jeff?
No, that's right on, man.
And Mary, do you have I saw your microphone came off. Do you have something to add?
I did have a question about the sort of application standards. I know it says that you guys are looking for sentences over 10 years. How strict of a rule is that? Like I had a client, for instance, who I thought got totally railroaded at trial in the pre-trial procedure, but, you know, got a relatively short sentence, but with sex offender registration. Do we refer those folks to the program, or is that person not going to get?
Absolutely. Listen, so all of those things are advisory. And that is precisely what it says in statute.
Okay.
It is advisory. We're not bound by those. I mean, we're going to have a tendency to prioritize by them. But the other side of this too is, like, I'm just going to tell you from a strategic standpoint, I'm looking for some low-hanging fruit. I want to take some W's back to the legislature. I want to be able to take this back to Rebecca Saldana and say, hey, listen, I just want you to know, look, we have corrected wrongs. And if that requires us to take a case that, to your point, might affect somebody's lifetime registration, like, look, yeah, we're like 100% interested in that, because like I said, we need to get some W's under our belt, ties by them. But the other side of this too is, like, I'm just going to tell you from a strategic standpoint, I'm looking for some low-hanging fruit. I want to take some W's back to the legislature. I want to be able to take this back to Rebecca Saldana and say, hey, listen, I just want you to know, look, we have corrected wrongs. And if that requires us to take a case that, to your point, might affect somebody's lifetime registration, like, look, yeah, we're like 100% interested in that, because like I said, we need to get some W's under our belt. And if we can pad those numbers by some easily identified, I think Jeff's got a case right now that Jody had remember the bank robbery that was included in the offender score? Like, he didn't have a sentence that comported with any of this stuff, nor did he have an age range or health or, you know, physical or mental health factor that came into this, but we want to get some wins. And I'm not trying to say like that there's nothing more important than the client, because there's nothing more important to me than the people incarcerated. They're your clients, they're my community. But practically speaking, strategically, it's going to be wildly useful for us as we seek sustainability and expansion to be able to show some wins. So if you have something that you've assessed as a win, I don't care if it's a 4-year sentence. You know, I would love for it to be something that we can carry across the finish line before the prosecutor starts arguing it's moot because the person's been released from prison. But like I said, we want some wins.
I'm not sure who conference is. I know that we're right at the end of the hour. I'm going to say that the answer to that question is that Jacob's doing his best to ensure appointment of counsel in as many cases as possible. They go through a screening to determine that the folks who are most in need, who meet the statutory requirements, or who are most in need, get appointed. I think the best thing that counsel can do, or folks from direct appeals can do, is just to apply. Just to apply and to apply and apply. Part of that will show the need for this program and the importance of this program. and that the resources are limited and that we don't have enough resources on them. And I think the thing that you can do to move this program forward more than anything is just apply. Fill out the forms, let Jacob see, or Jacob and the team see as much as they can about the case and why the injustice incurred in your case and what can happen there, but really just to apply and to get as many applications before. And that's going to be the lever that we can use to increase this program. This program is a priority. We want PRP counsel appointed in every case. And that can only happen if we can demonstrate the need for it. I'm going to close up one by really, Jacob, thank you for using my office, and thank you for sharing all of your knowledge today. It's really appreciative. I know Jacob put his text number into the, so Lisa, I think the question is probably to apply afterwards. Part of that is that part of the PRP process is to examine you and your steps along the way as well, and that can't be done if we start the PRP process beforehand. And since we only get one shot at it, it probably makes sense to decide whether we fulfilled our obligations too. I also don't know if it's a horrible thing to alert. We've seen it a couple of times, to alert Jacob to a case beforehand that you see that might be one of those cases that you're not going to be able to hit the issues on, but that the PRP process, so that they can be prepared for it. Let me also just say this. We are going to continue doing these meetings. We are going to do them for CLE credit because I like to do trainings. Next month, I think we are going to do the program is going to be about dependencies, family defense, and MDRs. Please, to get your CLE credits, don't forget you've got to fill out the survey, which is a very short 2-question survey, but it includes your bar number so that you can get credit for this. Please include in there what you think would be good topics for the sessions. We'll continue to do these on the last Thursday of every month at noon. And thanks everyone for coming today, Jacob especially, and Jeff also for you. Thank you for all of the questions that you had. It's nice seeing everybody.
Hey, Travis, I had a question. Somebody asked me, hey, listen, you can absolutely submit the application while your client is still on direct review. What we do is we make a note in the spreadsheet. We still review the case, and then we keep track of when the mandate comes out.
Yeah.
Yeah, I understand, Travis, that my tendency is to suggest clients wait. Oftentimes they want to jump ahead, especially when we can't get to the information, the evidence they want to introduce.
I know, Lisa, it killed me in this case because he's in his 90s. Yeah. And the issue in my case was not, there was nothing I could do on direct appeal for him. It was, right. I moved that case as quickly as I could through the process to get him to PRP, but I still had to file the brief, the reply, the petition.
I tend to advise them they get one shot, and it means they cannot review the appellate process, the decision, unless they wait, and then I let them decide.
Yep.